points specifying the geodetic datum. Nothing more is required. But even if Kenya's self-serving and unproven argument about unstable base points were tenable, which it is not, the solution would not be to resort to a parallel of latitude, which has no relation to the base points whatsoever, or in this case, to the actual direction of the coast. Instead, it would be to substitute a bisector for the equidistance line. That was the solution chosen by the court in Nicaragua v. Honduras, where, due to the unstable nature of the coast at the mouth of the Rio Coco, no reliable coastal base points could be determined. And as we saw a few moments ago, a bisector in this case, drawn from a straight line following the general direction of the relevant coast, closely approximates an equidistance line, whether drawn on the basis of United States NGA chart 61220 or British Admiralty chart 3362. Madam President, as Professor Miron explained, and as you can see directly from each of these depictions, this is not only an appropriate case for application of the three-stage methodology, it is an emblematic case for use of that methodology. If that methodology were not appropriate here, in the particularly unremarkable geographical circumstances of this case, it would be difficult to envision a situation where it should be applied. There is one technical issue, however, regarding stage one of the three-stage process that remains to be addressed. This concerns the starting point for the provisional equidistance line. Somalia contends that the equidistance line, and indeed any boundary line that could be drawn, must begin on the coast, at the low water line. Somalia's position conforms to Article 5 of UNCLOS, which states that the, quote, normal baseline for measuring the breadth of the territorial sea, and thus the starting point of any delimitation, is the low water line. Surprisingly, Kenya disagrees. It contends that the maritime boundary should begin on land, some 40 meters inland from the coast, at boundary pillar 29. The parties agree that boundary pillar 29 is the final marker on the land boundary between Somalia and Kenya before the boundary reaches the sea. Its precise geographic coordinates were disputed in the written pleadings, and Kenya again complains in the legal memorandum it submitted on 5 March that Somalia has incorrectly used astronomical coordinates without converting them to WGS 84. To avoid further argument over a minor technical point, Somalia is prepared to accept the coordinates proposed by Kenya for boundary pillar 29. Either way, BP 29 is located approximately 40 meters inland. But fortunately, this is not a unique situation. It was common practice for colonial authorities, such as those from Italy and the United Kingdom, who demarcated this land boundary in the 1920s, not to erect such pillars on the coast itself. Their surveyors knew that boundary markers placed too close to the sea are especially vulnerable to being washed away during major storms or slowly eroded over time. Thus, the same circumstance has arisen previously, and courts and arbitral tribunals have had little difficulty addressing it. They have done so by drawing a straight line connecting the final boundary pillar to the coast at the low water line, and then by constructing the maritime boundary from that point on the coast. In Ghana v. Cote d'Ivoire, for example, the final pillar demarcating the land boundary between these former British and French colonies was situated some 150 meters inland from the coast. The Atlas Chamber decided to connect that pillar to the coast by means of a straight line, along the same azimuth that connected the last pillar to the one immediately before it. It then constructed a provisional equidistance line starting from the low water line. Similarly, the arbitral tribunal in Guyana v. Suriname drew a straight line from the final boundary pillar to the low water line and then commenced the maritime boundary from that point. The logical solution here, therefore, is a straight line from boundary pillar 29 to the low water line on the coast, and then from that point, construction of a provisional equidistance line. Happily, in this case, the historical record tells us exactly how the straight line from BP 29 to the coast should be drawn. The boundary agreement of 17 December 1927 between Italy and the United Kingdom states that the land boundary extends from BP 29 to the sea in a southeasterly direction, quote, in a straight line at right angles to the general trend of the coastline, end of quote. Consistent with that agreement, Somalia has connected BP 29 to the low water line by means of a straight line perpendicular to the coast, as shown on this slide and at tab 53. The point at which this perpendicular line intersects the low water line is therefore the proper starting point for the maritime boundary. And it is from that point that Somalia has constructed its provisional equidistance line. The precise geographical coordinates of that point and of the entire provisional equidistance line are set out at tab 54 of your judge's folder. Madam President, in stage 2 of the three-stage process, to which I now turn, the court considers whether there are any special or relevant circumstances that would require an adjustment of the provisional equidistance line in order to achieve an equitable delimitation. The court and other international tribunals have repeatedly made clear that the special or relevant circumstances that could give rise to an adjustment of the provisional equidistance line should be geographical circumstances. The point was emphasized recently by the Itlos Chamber in Ghana v. Cote d'Ivoire, which explained, quote, according to international jurisprudence, delimitation of maritime areas is to be decided objectively on the basis of the geographic configuration of the relevant coast, and only in extreme circumstances may considerations other than geographical ones become relevant, end of quote. Although Kenya chose not to engage directly with the three-stage process in its countermemorial or rejoinder, it did identify 3 circumstances that in its submission rendered the provisional equidistance line inappropriate. What all 3 circumstances have in common is that none is geographical. None is based on the coastal or maritime geography specific to this case. The first of these circumstances is what Kenya euphemistically calls the regional practice. As evidence of such a purported practice, they cite just 2 maritime boundary agreements, both products of political negotiation rather than judicial settlement, which resulted in boundaries following a parallel of latitude. Both of these agreements were negotiated by a single state, Tanzania. One of them is an agreement between Tanzania and Kenya, to which I will return. The other is with Mozambique. These agreements are, as Professor Miron explained, res inter alios acta in regard to Somalia, and shed no light whatsoever on the delimitation of an equitable boundary between Somalia and Kenya. International jurisprudence has been clear in this regard. State practice, that is the practice of other states, is not a special or relevant circumstance that can be invoked to adjust a provisional equidistance line unless it rises to the level of opinio juris, which is not even alleged in this case. Nor could it be on the basis of just 2 political agreements involving the same state. The second circumstance raised by Kenya in opposition to the provisional equidistance line is what it calls the practice of the parties. The so-called practice that Kenya alleges is Somalia's purported acceptance of or acquiescence to the parallel of latitude that Kenya claims as the maritime boundary. My distinguished colleagues, Professor Pele and Professor Sands, have already shown you, as was previously made clear in the written pleadings, that there was no such practice, no such acceptance, no such acquiescence on Somalia's part. Nor is there any evidence that in practice, Somalia ever manifested an understanding that the parallel of latitude would constitute an equitable basis for the delimitation of its maritime boundary with Kenya. All of the evidence is to the contrary. Like Ghana, in its case against Cote d'Ivoire, Kenya argues that even if the conduct of the parties did not rise to the level of a tacit agreement, it should be regarded as a relevant circumstance sufficient to warrant an adjustment of the provisional equidistance line. The Itlos Special Chamber rejected both of Ghana's arguments, holding that there was no tacit agreement and that the conduct in question could not be considered a relevant circumstance requiring adjustment of the provisional equidistance line either. It ruled that if it were to reject Ghana's tacit agreement argument, but still consider Cote d'Ivoire's alleged conduct a relevant circumstance sufficient to require an adjustment to the provisional equidistance line, that, quote, would in effect undermine its earlier finding on the existence of a tacit agreement. This brings me to the third and final circumstance proffered by Kenya as a reason to dispense with the three-stage process and the provisional equidistance line: its maritime boundary agreements with Tanzania. Professor Marone addressed them briefly yesterday. I will discuss them in greater detail, and I will demonstrate why they cannot be considered relevant circumstances in this case. There are two such agreements. The first, which entered into force in 1976, delimited the Kenya-Tanzania boundary only from the coast to the 12-mile limit of the territorial sea. The second agreement, dated 30 July 2009, delimited the remainder of the maritime boundary between the 12-mile territorial sea limit and the outer limit of the parties' extended continental shelf entitlements. The second agreement established a boundary along a parallel of latitude. Notably, the latter agreement, in July 2009, was made 3 months after Kenya's maritime boundary dispute with Somalia had become manifest, as reflected in their Memorandum of Understanding, dated 7 April 2009. Kenya was thus fully aware of Somalia's claim that the boundary should be an equidistance line at the time it agreed with Tanzania on a boundary that would follow a parallel of latitude. This slide, which is also at tab 55, shows in blue the notional equidistance boundaries between Somalia and Kenya in the north and between Kenya and Tanzania in the south. It also shows in black the territorial sea boundary agreed by Kenya and Tanzania in 1976, and in red the continental shelf EEZ boundary agreed by those two states in 2009. Kenya claims that the combined effect of an equidistance-based boundary with Somalia and its own 2009 boundary agreement with Tanzania would be a cutoff of its maritime entitlements, especially in the extended continental shelf beyond 200 miles. Before examining whether Kenya, as it alleges, is significantly cut off from its maritime entitlements, it should be emphasized that, as a matter of law, it makes no difference here. Kenya's agreement with a third state, whatever its impact, is not a relevant circumstance that could merit an adjustment of the provisional equidistance line with Somalia. The court confirmed this point in its most recent maritime boundary decision. In Costa Rica v. Nicaragua, Costa Rica argued that it sat in the middle of a three-state concavity, such that an equidistance line with Nicaragua, in conjunction with its prior delimitation agreement with Panama, would produce, quote, a cutoff effect for Costa Rica's seaward projections. Kenya's recent written submission of 5 March echoes Costa Rica's pleading. Word for word, it claims that Kenya lies in the middle of a so-called 3-state concavity. The court flatly rejected Costa Rica's argument, as reflected in this sketch map from the judgment. It ruled that the, quote, overall concavity of Costa Rica's coast and its relations with Panama did not merit adjustment of the provisional equidistance line with Nicaragua. As the court explained, in considering whether the alleged cutoff was a relevant circumstance, the only pertinent question was, quote, whether the seaward projections from Nicaragua's coast create a cutoff for the projections from Costa Rica's coast as a result of the concavity of that coast, end of quote. Because that cutoff, the one caused by Nicaragua's coastal projections, was insignificant, the court found that no adjustment of the equidistance line was warranted. As the court explained, quote, a judgment rendered by the court between one of the parties and a third state, or between 2 third states, cannot, I emphasize cannot, per se affect the maritime boundary between the parties. The same applies to treaties concluded between one of the parties and a third state, end of quote. That is precisely the situation here, and the result can be no different. Indeed, Kenya's situation is far less sympathetic than Costa Rica's. Even if the so-called cutoff created by Kenya's decision to agree to a parallel boundary with Tanzania, at a time when it was fully aware of Somalia's equidistance claim and the consequences thereof, were relevant to this delimitation, which it is not, it would still not make any difference. The purported cutoff is not significant enough to merit an adjustment to the provisional equidistance line. As shown in this slide, and at tab 55, the parties' relevant coasts project to the southeast. The equidistance line between Somalia and Kenya follows exactly the same general direction. It does not cut off either country's coastal projection. In fact, it does exactly what delimitation lines are supposed to do, as the court prescribed in the Black Sea case, quote, it allows the adjacent coasts of the parties to produce their effects in terms of maritime entitlements in a reasonable and mutually balanced way, end of quote. Kenya complains that the combination of an equidistance line with Somalia and its agreed boundary with Tanzania, quote, substantially narrows Kenya's coastal projection into its EEZ from a coastal length, measured as a straight line, of 424 kilometers to only 180 kilometers measured at the 200-mile limit, end of quote. That may be true as a matter of simple arithmetic, as shown here and at tab 57. But the case law does not support the conclusion that an adjustment to the provisional equidistance line is warranted in circumstances like these. Indeed, Bangladesh was left worse off in its adjudicated delimitations with Myanmar and India after both equidistance lines were substantially adjusted than Kenya would be in this case without an adjustment. The adjustments the two tribunals made to the 2 provisional equidistance lines left Bangladesh with a narrower coastal projection than Kenya would have. If the court were to adopt an equidistance line as the boundary with Somalia, as you can see, Bangladesh's coastal facade, rendered as a straight line, measures 340 kilometers, but shrinks to just 103 kilometers at the 200-mile limit after adjustment of the provisional equidistance line in Bangladesh's favor to relieve it of some of the prejudice caused by its severe coastal concavity. Kenya finds itself in a superior position to Bangladesh without an adjustment of the provisional equidistance line. It thus has no good argument for one here. Kenya further complains that the provisional equidistance line, quote, prevents Kenya from having any entitlement out to the edge of its continental shelf. That, too, is irrelevant. There is no right to a boundary that enables a state to reach the maximum limit of its potential continental shelf entitlement. Looking again at the Bangladesh cases, as depicted here and at tab 58, the final delimitation lines adopted by ITLOS and the Annex 7 Tribunal stopped Bangladesh's continental shelf 115 miles short of the outer limit of the entitlement it claimed in its submission to the CLCS. As the tribunal in the Bangladesh-India case observed, quote, international jurisprudence on the delimitation of the continental shelf does not recognize a general right of coastal states to the maximum reach of their entitlements, irrespective of the geographical situation and the rights of other coastal states. Bangladesh had a much stronger claim for an adjustment than Kenya. Bangladesh did not cut itself off by an agreement with a third state. It was cut off by the deep natural concavity of its coast, a circumstance over which it had no control. Kenya, in contrast, voluntarily shortened its own extended continental shelf entitlement by agreement with Kenya. The next slide makes this perfectly clear. In 2009, if Kenya had pressed for an equidistance boundary with Tanzania instead of a parallel of latitude, it would have secured for itself, as shown here and at tab 59, an extended continental shelf all the way to the outer limit of 350 miles, comprising more than 25,000 square kilometers, even if the boundary with Somalia were also an equidistance line. Now you can see exactly how high a price Kenya paid for agreeing with Tanzania to depart from equidistance beyond 200 miles. The effect of Tanzania's Pemba Island on the equidistance line, pushing it northward, ended well short of the 200-mile limit. It did not have any impact beyond that distance. It thus appears that Kenya deliberately chose to surrender more than 25,000 square kilometers of maritime space beyond 200 miles for a gain of just 10,725 square kilometers within 200 miles. It is not for Somalia to criticize Kenya's choice, but Somalia insists that Kenya has no right to make it pay for the consequences of that choice by adjusting the Somalia-Kenya provisional equidistance line as compensation to Kenya. As the arbitral tribunal held in Barbados v. Trinidad and Tobago, quote, Barbados cannot be required to compensate Trinidad and Tobago for the agreements it has made by shifting Barbados's maritime boundary in favor of Trinidad and Tobago, end of quote. In its legal memorandum of 5 March, Kenya added a potpourri of other so-called relevant circumstances that purportedly warrant an adjustment or even an abandonment of the provisional equidistance line. In this new submission, Kenya gave particular emphasis to the alleged interests of its fisherfolk and the purported need to protect its security. Neither of these circumstances is geographical, and neither justifies a departure from equidistance. In regard to fisherfolk, Kenya has helpfully provided us with maps showing what it calls the, quote, prominent fishing grounds they frequent. Our cartographic experts have georeferenced them and superimposed them on this sketch map, which is at tab 60. As you can see, all of these allegedly prominent fishing grounds are to the south, that is, on the Kenyan side of the equidistance line. There is thus no impact on Kenya's fisherfolk. But even if, quod non, there were, the fishing practices of Kenyan fisherfolk are not a relevant circumstance for determining the course of the maritime boundary in this case. This is because, even if it is assumed that they might suffer some injury, no evidence has been submitted of any potentially catastrophic impact on the livelihood and economic well-being of the population, as this court's jurisprudence from the Gulf of Maine case through the judgment in Nicaragua v. Colombia requires before such interests can be taken into account in the delimitation of a maritime boundary. In any event, although it is under no legal obligation to do so, Somalia is willing to enter into a fisheries agreement with Kenya to secure the ability of fisherfolk from both states to continue exercising their livelihoods in the areas they have traditionally frequented. But this does not affect the delimitation of the maritime boundary. In regard to protection of Kenya's security, it cannot be denied that at this point in historical time, the difficulties faced by Somalia impair its ability to prevent cross-border piracy or IUU fishing. But this is not a relevant circumstance justifying adjustment of the equidistance line either. Until now, the court has been willing to take account of a state's security interests in delimiting a maritime boundary only to prevent the line from crossing closely in front of the state's coasts. That is not even remotely the situation here. Even Kenya does not argue that it is. Where, like here, the provisional delimitation line does not cross in front of a state's coast, the court has been unwilling in its prior cases to treat the alleged security interests as a circumstance sufficient to justify adjustment of the line. Indeed, it would be a dangerous precedent to draw a boundary based on which state is strong enough to enforce it, which is what Kenya's argument ultimately boils down to. Might cannot be allowed to substitute for legal right, in this case, Somalia's right to an equitable boundary drawn in accordance with the rules of international law and the procedures of maritime delimitation that the court has consistently applied. Accordingly, Madam President, none of the circumstances invoked by Kenya, either in its formal written pleadings or its newest supplement, or as Professor Marone refers to it, Kenya's rejoinder bis, constitute grounds for abandoning the three-stage process or for adjusting the provisional equidistance line in Kenya's favor at stage 2 of this process. The result is that at the end of the second stage of the process, the provisional equidistance line remains intact. No adjustments are required or justified. This brings us to the third and final stage of the three-stage process. As the court explained in the Black Sea case, at this stage its role is to check whether any disproportionality exists in the ratios of the coastal lengths of each state and the maritime areas falling on either side of the delimitation line. In its jurisprudence since the Black Sea case, the court has elaborated on the nature of this disproportionality test. It is not to determine whether the provisional equidistance line, as adjusted or not in stage 2, distributes the disputed maritime space proportionately, but to determine whether that distribution is significantly disproportional. In both Nicaragua v. Colombia and Costa Rica v. Nicaragua, the court explained that it is only when there is a gross disproportion that the provisional equidistance line will be considered inequitable. Unless the distribution of maritime space is grossly disproportionate, the court will not adjust or further adjust the equidistance line, and that line will be deemed to constitute an equitable boundary. By way of example, in Nicaragua v. Colombia, the court did not consider a coastal length ratio of 8.2 to 1 and a relevant area ratio of 3.4 to 1 to be so disproportionate as to render the delimitation inequitable. Here, the provisional equidistance line produces no disproportionality.